All rise. The Court of Appeals Division 1 is now in session.
Thank you. Please be seated. Good morning. We're here for oral argument in case number CV21-0543, LUYET versus MARIPOSA Landscape. These proceedings are being video and audio recorded, so we ask counsel to please identify yourselves and your clients at the beginning of your argument. Each side will have 20 minutes. Appellant's counsel is responsible for watching the clock to reserve a portion of that time for rebuttal if so desired. Also, we have read the briefs and have conferenced the case. And with that, counsel, you may proceed.
Good morning, Your Honors. My name is Rebecca Baines. I represent the state of Arizona, and I would like to reserve about 3 minutes of time for rebuttal this morning. I would like to address two main issues this morning, the first being this court's jurisdiction over this appeal, and the second being the Superior Court's abuse of discretion in granting the motion for new trial that followed a jury verdict. But to first address the jurisdiction issue, this analysis is actually very straightforward and simple, and because the plain language of ARS Section 12-2101 A5A gives this court jurisdiction over an order granting or refusing a new trial. And it's that simple. That particular subsection of the jurisdiction statute does not include a finality language. And that was a legislature's choice to make, unlike its decision in other subsections of the same statute. So the suggestion that an underlying final judgment was required here before appeal has no merit, and this court should not read a finality requirement into it. I would briefly address the Maria versus Nahara case that's been cited and is somewhat responsible for this discussion of finality, even though A5A does not ask or does not require a final judgment. That case involved an appeal from an order that was appeal from an order on a motion for new trial that was directed at a non-final partial motion for summary judgment. And that's very different from what we had in this case, which was a motion for new trial that was actually directed at a new trial itself. So the court in Maria did ultimately explain that what is now A5A could not be the basis of jurisdiction in that case because there was no trial below. Instead, it had to look at what is now subsection A2, which grants jurisdiction over special orders made after final judgment, and therefore the court was also required to go into the analysis of whether there had been a final judgment through Rule 54B or Rule 54C. None of that comes into question or is implicated in this case, where again there was a motion for new trial actually directed at a trial itself in the order that actually granted a new trial. So we'd ask that this court hold that it does in fact have jurisdiction over subsection A5A.
Okay, counsel, moving past the jurisdiction issue. So in the state's opening statement, it says, what this case is really all about is whether the state is responsible for people who stand in the street on Grand Avenue at 4:40 a.m. in the morning in the dark. So how does that not go to the precluded issue of causation that the state, in fact, had asked for the bifurcated trial, correct?
Yes, the state did ask for a bifurcated trial.
And the first trial was to solely be on the standard of care at the time. So how does that not violate the motion in limine?
So phase one included two things, both the state's negligence, as whether it breached its common law duty to keep its roadways regionally safe, as well as the state, whether or not the state met its affirmative defense under ARS 12-820-03. So that was sort of the parameters of the phase one trial. And what the pretrial motion in limine that's at issue here broadly asked the court for an order that precluded the parties from referencing precluding all parties from raising issues in front of the jury other than the state's negligence, and the elements are of ARS 12-820-03. Now, the only specific piece of evidence that was referenced in that motion was that of Mr. Haggerty's intoxication. And the order granting that motion was just as broad. It says the motion is granted. Whether Mr. Haggerty was intoxicated is not a relevant inquiry into whether the design was negligent. So I'll first say that at no point in time was there any mention of a trial before the jury, any evidence of Mr. Haggerty's intoxication, his activities the night of the accident, or any reference to alcohol. So for the court to have...
I'll agree with you that the word intoxication wasn't used, but the statement, people who stand in the street on Grand Avenue at 4:40 a.m., I mean, how does that not allude to potential intoxication or allude to the precluded issue?
So, a couple points. So I think that the statement was intended to reflect the extent of the state's common law duty, which is not to provide perfect streets, and what exactly is the state's obligation. What is this? By providing reasonably states, what does that require, and what are the expectations of ordinary users of the road, which all was testimony that the jury did hear. And I think that those particular statements were given to provide some context about what this accident was going to be. And it can really, I mean, the jury absolutely knew that this accident involved a pedestrian vehicle accident at night in an industrial area, and knew that the pedestrian was in the road. I mean, that came in several times throughout the trial from both the plaintiffs and without objection. So that was the purpose of those statements, and it was in fact to provide some context, and it was not an intent to improperly inject comparative fault or causation issues into the trial. So even if we're considering those issues, they did not violate the motion in limine, which I'll again say was very narrow and specifically excluded only evidence of intoxication. And when you look at the Superior Court's order granting the new trial, it did in fact say that the state it relied on the state's intent to create that implication. But there's just no basis in the record for that finding when you look at what the actual evidence was that the jury heard, which is what the question is.
It seems that trial counsel here made every effort to be as inflammatory as possible within the confines of an opening statement, right? I mean, the limited purposes of this trial did not require bloviating about a nanny state. This was the kind of stuff that I think probably could have upset many trial judges. And so the question that I would ask you to answer very specifically is how do we apply the abuse of discretion standard in this context? Because I believe we ask whether any reasonable trial judges could have reached this conclusion on this record. And I have a very hard time saying that every trial judge who might have been inclined to rule this way is not a reasonable trial judge. So am I misunderstanding the standard of review?
No, the standard of review is an abuse of discretion, but that's not complete unfettered exercise of discretion, and there still must be a basis in the record for its decision. And I think in this case, the trial judge was aware, based on pretrial filings, of the fact that Mr. Haggerty had been intoxicated, and then he had that. The court had that in its mind when it granted the motion for a new trial. But that's not the end of the inquiry, because to grant a motion for a new trial, there has to be prejudice.
I'm asking how we interpret the standard. You're going through the steps of the analysis, which is legitimate but not responsive to my question. So am I correct in saying that we would conclude that this is an abuse of discretion if no reasonable trial judge would have granted this motion, or is there another way to phrase the standard?
I think the standard of review is whether the trial court abused its discretion in reaching this conclusion.
Yes, and how do we then define what that means? Because the formulation I gave you is the one I'm most familiar with. As I've written before, though, abuse of discretion is a little bit like nailing a jellyfish to the wall. It's a very, very flexible, amorphous standard. And so if there's a different way to think about it in this context, I'd like you to address that specifically.
Yeah, so I think you're correct. The standard of review is whether the court abused its discretion in granting the motion for a new trial and whether or not a reasonable judge could have concluded that. But again, you do still have to look at the trial courts are bound by correctly applying the law and having a basis in the record for finding their decision. So I think that also sort of the steps or analysis are important when considering what the standard of review is. It's not a completely unfettered ability to exercise any discretion that will be upheld on review, and that includes in the granting of motion for new trials and when prejudice is alleged.
But if it will be upheld on review, isn't that the essence of the discretion the trial court has?
So not every exercise of discretion that will necessarily, it has to have a reasonable basis in the record to be upheld on review. I'm just saying that the fact that it's an abuse of discretion is not necessarily an impossible standard or a toothless standard, but rather when you're asking what is an abuse of discretion, well, it's making a decision that goes, that has no basis in the law, no basis in the record, misapplies the law to the facts of that case.
But can't a trial judge just... There's lots of granularity here as to orders in limine and bifurcation and everything, but even if we take those away, can't a trial judge determine that the way counsel tried a case was too inflammatory and prejudicial to represent a fair trial, so we're going to do this one over?
If there was a basis in the record for making that finding, sure, a judge could make that finding. But I'll
tell you what, the nanny state comment wouldn't have gotten past me as a trial judge. I would have objected sua sponte.
Well, I'll say that, but the trial court did not do that in this case. And I think so that's an important thing to recognize, is that this one comment, even if it overstepped a line or misstated something improperly, it was a sentence in the beginning of the state's opening. This misconduct was not peppered throughout the trial. There was no further allusions to it. In the cases where judges are saying that, yes, there was misconduct, you had references in closing arguments. Like the Leahy case, alcohol was mentioned at least 11 times, I believe. The Stiles case involved, multiple experts as opposed to the other side's one. So those are cases where courts are saying, this trial was, so poorly tried. It was clearly an intent to infuse irrelevant and improper information into the trial. That is not this case that we have. And as you mentioned, there was no attempt to address this or to cure this issue at all during the trial, and that is very problematic.
But is it an absolute bar to curing it after?
It is, unless the misconduct was so egregious or of such a nature that it could not have been cured at trial. And if you look at the court...
Can we say the offending statement at the very beginning where counsel begins with, this case is ultimately about, and then ends with protecting perfectly functional adults from themselves, can we really say that that did not set the pace, really set the stage for how the jury would receive the evidence?
I don't think you could say that it necessarily set the stage so that is how the jury would have heard it. When it's also looked in context of everything else that was presented in the trial, including in the opening statements, where it was made clear, was this case, was it about as in the terms of the state's negligence, or whether or not it met its 820.03 defense.
Given the bifurcation, I struggle to find a single word in that excerpt to which Judge Cruz just referred that has anything to do with anything that was legitimately before the jury. It seems the entire thing was couched to inflame based on matters that had been excluded from the very bifurcated trial that your client requested. So what in this, what one even conjunction relates to anything that was legitimately at issue?
Well, I think that, again, so this case was about an accident in this case and whether the roadway was properly designed. So yes, there were statements that were made that gave the jury some context about what was going to happen, and I believe that the statement was made to put in context how far the state has to go in designing its roadways and whether or not those are reasonably safe.
Right. So the case was about engineering guidelines, recommendations, and then the trial counsel goes on to say, yeah, about all that stuff. What this case is really about, and then goes off into the stratosphere completely outside the judge's ruling, and which was issued in response to the state's own request to bifurcate the trial in its own way, and then it changes the rules with the jury present in the courtroom. It's not hard to imagine how a trial judge might find that that's not turning a square corner.
we can agree for the argument, just for the sake of argument, that even saying that the statement was improper, that it overstepped some sort of bounds, and it, or it had nothing to do with the issues. Assuming that were to be true, which we don't necessarily concede, that's really not the end of the inquiry. And even if a reasonable judge could have thought that, there was things that could have been done in this trial before the case was given to the jury and came back with a defense verdict that was in fact supported by the record.
But then that brings us back to the original question, which is, assuming, as you've said, assuming that's true, then wouldn't that be enough to support to support a ruling that it was not an abuse of discretion? Wouldn't it be enough to anchor the judge's decision to grant the motion for new trial?
Not if there's no evidence in the fact, or no evidence in the record to support a finding of prejudice against the plaintiffs. And this statement has been being viewed in a vacuum, in complete isolation, and not in context of both what all happened at trial.
Well, I'm looking at it in the context of counsel opening with, you're going to hear all of this information. You're going to hear engineering guidelines, recommendations, reference manuals. But it's not about any of that. Really, it's about whether people take care of themselves and are responsible, or essentially putting themselves in harm's way, and whether the state should be responsible for them. And I'm putting that in context with the fact that the jury, how long did it take them to deliberate?
It was a short deliberation, I think 20 or 30 minutes.
Right. Not enough to go through the reports, the guidelines, engineering guidelines, recommendations. Essentially, can't we get to a conclusion that maybe they took the shortcut to what this case was really about, according to counsel?
I don't think you can make the assumption that the jury must have taken that shortcut, as opposed to making a decision based on all of the evidence that was presented at trial, and could have just assumed, it was in fact...
Could they have really talked about all of the evidence that was presented at trial in, you said 20 to 30 minutes, I think, but I
think it was about 20 minutes, if I'm remembering correctly.
Okay.
I don't know what in the record that was.
And is that from the time they left the courtroom to the time they came back?
I don't recall. I think someone, I'm sorry, I don't recall the time.
So not enough
17
time.
minutes into this argument, we've barely been able to talk about anything.
Yeah, I just think that again, this one thing is being assumed that had all of this import to the jury, that they must have assumed that the state intended to imply that he was intoxicated and unable to take care of himself, as opposed to whether or not the state negligently designed a roadway, that it was an industrial area where there's no pedestrians, of which there's expert testimony to prevent both pieces. It was a split verdict, which could go either way. So I think to make the assumption that the jury's verdict was not based on the actual evidence in the record that was heard, but rather one sentence or a few sentences in the state's opening is improper. And to find prejudice, you have to be able to show that it appears probable that the misconduct affected the verdict. So I think that's the standard of review. And I'll also just say that I do think that the plaintiff's waiver is problematic in this case. When they had every opportunity to raise this issue contemporaneously or outside the jury's presence, really at any time before presenting a mistrial, it's clear this was a tactical decision. And when the verdict did not go their way, that's when they raised this issue. But the courts, or the case law, makes it clear that conduct is not proper, and it does in fact bar these claims. So I'm happy to answer other questions, or I'll reserve my time.
Thank you.
Thank you.
May it please the court, good morning. Matthew Millay for Frank LUYET, and Jennifer Haggerty. With me today is Mark DePasquale. I want to pick up on the last thing that counsel said about the waiver issue, because I think it's been misrepresented continuously by the state. If we look at the Supreme Court cases, they state this rule, and they state it repeatedly. State versus Briggs says, a properly made motion in limine will preserve appellant's objection without need for further objection if it contains specific grounds for the objection. State versus Lujan, in cases involving motions in limine properly made and ruled upon by the trial court, however, we have consistently held that the objection raised in the motion is preserved for purposes of appeal without a specific objection at trial. State versus Burton. However, when a motion in limine is made and ruled upon, the objection raised in that motion is preserved for appeal, despite the absence of a specific objection at trial. Liberatore versus Thompson, which is a case from this court, we know of no rule, nor would we adopt a rule, that a lawyer has insufficiently preserved an objection to improper argument by embodying that objection in a successful motion in limine in advance of the argument. Now, what happened in this case was we did, in fact, rely on that law, and we did not object in front of the jury. At the next break, I brought up with the judge, and this is in the record, in the transcript, I brought up with the judge that there was an issue with another motion in limine that I believe counsel had also violated by disclosing new testimony from a witness that had not been disclosed before. Before I could get to the issue of all these prejudicial statements that Mr. Horn intentionally made to the jury at the very outset of the case, the judge grew angry and said that he wanted to let him know that the statements that he'd made concerning the time of day and the age of the person involved and that kind of thing were all clearly not relevant, and he thought that we had discussed this several times before. And that's the thing, is that you have to take into account what was going on in this case, because there was quite a bit of discussion over several motions over what the scope of this case was going to be and what the scope of the trial was going to be. And the judge very clearly said that he wanted this to be a mini trial on the issue of whether the state's design of the roadway was negligent and whether there were hazardous conditions out there that the state needed to warn the public about. In the context of this case, there's simply no way that Mr. Horn could have believed that the statements that he made in opening statement were within the court's order.
But counsel, to the state's point, when you had that sidebar and the judge raised these issues, why didn't you object at that point and give the state, a potential opportunity to remedy the issue?
Well, it wasn't a sidebar during the opening statement itself. It was outside of the presence of the jury. And what happened was I made a decision that I was not, well, this is what I told the judge on the record, is that frankly I was flabbergasted that he would do it in the context of this case, because everybody knew very well how sensitive the issue was, that we were not going to be talking about what the fault of the decedent was in this case, because we didn't list any of that evidence, and we have evidence to rebut all the arguments that he was making. But the other thing was that the judge pointed it out to defense counsel himself. So I didn't feel that I needed to make a further objection when the judge was saying, in effect, you've already violated my order in opening statement. So at that point, there wasn't anything that could be done about it. That I didn't ask for an instruction because I didn't think it was going to do any good, to be honest.
Well, then why would you let the trial continue? Can you see the state's point that this can be viewed as a potential tactic? Let's wait and see what happens. If we lose, then we'll file our motion. Then we'll object.
I don't think that's what I need to do. It's not my obligation to keep the state from intentionally violating motions in limine in the opening statement at the very outset of the trial. And in terms of primacy, lawyers practice their opening statement for trial because that's exactly what the jury wants to know, is what's the case about? And what Mr. Horn did was he got up and told them it was about something that it wasn't about. And we were there to try the case. And I cannot by myself make him follow those orders, but the judge chose to do what he did, which is point out to him that he was outside of what was relevant in that trial. So I don't see the state's point. I think I was entitled to rely on the case law that says, do this at your peril. If you're going to intentionally violate a motion in limine, and it's possible that you could go through that whole trial and you could end up having to do it again because you intentionally violated it. It was obviously a very material and important issue, and there was plenty of evidence that this judge saw by observing the entire trial that the outcome might well have been different had he not committed those violations. And that's what he had an opportunity to observe, is he had an opportunity to act as, in this case, effectively as the 10th juror. And that's why there's so much discretion, so much deference given to the trial judge's view of the evidence and what was happening in the courtroom. I also wanted to bring up because counsel's done it again here today, they keep saying that there was only one statement in the opening statement that we focused on, and that's just simply not true. If you look at the motion for the new trial that it's item number 316 in the record, the first thing we talked about was that his statement that the trial was ultimately not about engineering, and this is the nanny state, but whether the state is responsible for people who stand in the street on Grand Avenue at 4:40 a.m. in the morning in the dark in that industrial area and get hit by oncoming traffic. And then he said, and this is also quoted in the motion, so again, as you heard before, on November 19th, 2016, a Saturday morning around 4:40 a.m., a pedestrian was in the roadway and was hit by a driver who was going to work. Number 3, this particular trial isn't about what happened and did not happen in the collision. All this trial is about, it's about the engineering, about what was required and or not required by the design of Grand Avenue in the area. And the reason that statement's important...
Doesn't that last statement play right into the orders in limine? That's not objectionable, is it?
No, but it shows that he understood what was and was not relevant. And that's what Judge Brodman focused on. And that's why we brought it up, because it's not as if he can get up there and say, I didn't know I couldn't say that. He definitely knew it because he went on and contradicted himself in effect, because earlier he had said it was really about individual responsibility, which frankly is code word for this person didn't take care of himself and now he wants to blame us. The fourth statement was, what this case is about is whether people should be expected to take perfectly good care of themselves when there's no sidewalk in an industrial area where there's clearly no lighting that anyone looking at would be able to tell, or whether the state should be required to serve as a nanny state and protect perfectly functional adults from themselves. And Judge Swan already brought up that statement, but there's another one that we also brought up in the context of, if you look at the Levy versus Parcell case, the court talks about the ethical rules that apply to attorneys, and especially Rule 3.4 that deals with statements made during opening statement. And I quoted this statement in that context because Mr. Horn said, there's a reason people don't use the word trust and lawyers in the same sentence unless it's a joke. So we didn't just bring up one sentence from this opening statement. We brought up 5. The judge brought up another one, which was the problem of saying that the trial was really about individual responsibility. So what he was telling the jury at the very outset, when they were trying to figure out what this case was about, was that it was really about the decedent's behavior. And in the context of this case, where there had been several hearings, several motions discussing what was going to be in and what was going to be out in this case, the judge was well within his discretion to say that warrants a new trial in this case.
What's your position on the state's view that the motion in limine solely precluded information about the victim, or Mr. His intoxication, Gavin's intoxication, and nothing more? So the fact that they didn't use the word intoxication means they complied with the order.
It's pretty hard to read either the motion itself or the judge's grant of that as not including causation, damages, non-parties at fault, essentially every other issue.
Based on what? Is that on the
actually,
order the court issued?
It's actually, it's in the motion that he granted.
Mm-hmm. Okay.
There was not a separate written order about that. But I thought that was going to be non-controversial, to tell you the truth, when I filed it. But I just had a feeling that given Mr. Horn's attachment to the intoxication issue, that he might try to get it in some way. And that's essentially what the judge found, is he said, look, what else is the jury to think? Why is it relevant that it's Saturday morning? Why is it relevant what time this occurred? Why is it relevant that this person's perfectly functional? All those things were a clue that there's something going on here, folks, that plaintiff's counsel didn't tell you about in his opening statement, but I'm going to imply it to you now. And that's where the prejudice comes from. He knew that he wasn't supposed to do that. And I guess, they bring up this waiver argument in spite of the fact that there's all this case law saying I don't have to object, and there's other case law saying I don't have to file for a mistrial. And I guess what seems unfair to me about that is I didn't intentionally violate any orders of the court. Mr. Horn did. And the judge found, and he had plenty of evidence to believe that counsel for the state intentionally violated his orders. And that's why the Levy versus Parcell case applies. And if you read the case carefully, it's very clear that it's very difficult to show prejudice when something occurs in opening statement. But what Justice Feldman said there was, in a closed case, which this was, according to the trial judge, then we need to err on the side of deciding that there's probably prejudice, because we're dealing with intentional misconduct from lawyers, and we don't want to tolerate that in our trial courts.
Really quick, as to the jurisdiction issue, ARS 12-2101, an appeal may be taken to the Court of Appeals from the Superior Court in the following instances. 5 says, from an order granting or refusing a new trial. So how, doesn't this plain text, the statute I just read to you, doesn't that support the fact that we have jurisdiction? And it says granting or refusing a new trial, an order granting or refusing.
I think you could ask the same question about the question of jurisdiction in the Maria case, because there the judge had refused a motion for new trial. So if you wanted to say that the statute was clear, then you could have said, the Court of Appeals could have said, well, it looks like a motion for a new trial was refused, so we have jurisdiction. And what the court in Maria did was say, look, both the legislature and the courts have a concern about finality. And I think it's really important here, because we have two other parties that weren't even part of this initial trial. And what this was an interlocutory verdict. No judgment was entered. In a sense, the trial's not over.
The legislature's not obsessed with finality. I mean, there are other examples in 2101. For example, the denial of a request for preliminary injunction is appealable.
Sure.
I mean, there are all kinds of non-final issues that are appealable. I'm just curious, now having discussed the merits, why you would lean on the jurisdictional point. How does it help you, given the posture of this case, to do this later?
Well, I understand that, but I also was, in filing the motion to dismiss, our interest is getting this case back to the trial court so that we can try the case. I mean, this is a death that occurred in 2016. We're coming up in a couple months on the 6-year anniversary of it, and we still haven't gotten the merits to trial yet. And that's the problem, frankly, with a statute that says, despite what Rule 42B says, that the state's entitled to a separate trial on this issue.
I would agree with you that sometimes it would be a lot more efficient and more convenient if the legislature would cast these sort of special appeals as special actions rather than as appeals, but it just hasn't done so. So, I mean, reading the plain language of the statute, I would think that we are not straying from it by one word if we consider this case on the merits.
I think that you are, and the reason is that the trial court's not done here. I mean, there's no way to see
Well, it's
this.
not done when it denies a preliminary injunction.
Okay.
It's not done when it makes, I mean, sometimes it's done, but not always when it makes a final order, a special order after judgment under A3. I mean, there are a number of times when the trial court takes action that is course determinative but not final. And our statutes specifically confer appellate jurisdiction on the appellate courts.
Well, and this is, I think, the oldest part of the statute, and it goes back to 1913. And at the time, the new trial motions had a much more limited purpose than they do now. And in other words, there had to be a judgment entered before you could even file the motion for new trial. Now you can file it basically to reconsider any decision or verdict or order that you want to.
Is the antiquity of the statute's part of the majesty of the law?
I think it is. It was fun going back and reading how they did things back then in 1915 and so forth. But they would actually dismiss cases if they were filed, if the motion for new trial was filed prematurely. And I think the problem we're going to have here is that if the legislature is going to start saying that the trial courts have to bifurcate these trials, then the question's going to come up again and again. Well, does that mean if somebody files a motion for new trial after the first phase, can they go ahead and go up and take that up to the Court of Appeals and even the Supreme Court? And is there jurisdiction for that? Is the trial even over? This trial was seen as having two phases, the second one of which we've effectively been stayed from doing because of this appeal. And it's difficult for us to accept that, especially under circumstances where the reason we're here is because of intentional misconduct by defense counsel in the opening statement. So it seems to me to raise a significant issue given the nature of this statute and the controversy over it that I can tell you is going on in the trial courts. Is it reasonable to, and does the statute actually allow somebody to appeal a trial verdict or a motion for new trial following a trial if there's in fact no judgment at all and it's not really the end of the trial? It seems like it's almost like taking an appeal while the trial is still going on, in effect, because that's essentially what's going on, and we're now hung up and can't try the second phase of the trial because of this. If there are no other questions, I appreciate the court's time. Thank you.
Thank you, counsel.
Thank you, Your Honors. I'll begin with the waiver issue. And most of the cases, not all of them, but most of the cases the plaintiff cited involve cases where the pretrial motion in limine was lost. And yes, in those cases, when you actually look at what happened in the case law that we've cited, there's no obligation to then re-raise the objection at trial because you're just essentially asking the court to reconsider its ruling. And there are really no cases where, well, this case, something like this happened where you had a pretrial motion in limine, it was granted, the other party violated that order or was alleged to have violated that order, and the courts condoned not objecting at trial. I mean, the Liberatory case, which plaintiff cited, did in fact include objections and specifically a request for a mistrial. So the case law doesn't support, even though there's seemingly favorable language about motions in limine preserving objections, that is only the case when the pretrial motion in limine has been denied or there is some objection raised at trial. And that goes to the same points that Your Honor was raising, that had there been an objection, had plaintiff chosen to ask for some either a curative instruction or even a mistrial, if it was so egregious after the opening statement when the court brought it up himself, the court could have addressed it in the way that it thought was proper. Instead, they let the entire trial play out without re-raising the issue with the judge at any time. And the case law just doesn't support, as we've laid out in our briefing, that you can not object at trial and preserve the issue for appeal. So we would ask that this court finds that the issue has been waived. I would also say that, again, our position that there was no misconduct, that the order was not violated. The order itself is at RA 285, where the court goes through and issues its ruling on the motions in limine. And again, he says that the motion, referring to motion in limine number 5, is granted. Whether Mr. Haggerty was intoxicated is not a relevant inquiry into whether design was negligent. That was the extent of the court's order, written order distilling its ruling on the motion limiting number 5. So we would ask that this court reverse the order granting the new trial.
Thank you.
Thank you, Your Honors.
Counsel, we thank you for your arguments. This matter is now taken under advisement, and we will issue a written decision in due course. We are adjourned.